Welcome once again to our continuing YouTube video series on wills and estate planning. My name's Christopher Neufeld of Neufeld Legal, and in this particular YouTube video we'll be discussing what is not in a will. And first and foremost, and this is always should be remembered, what you don't write in a will not appear in a will. So it's critical that the contents that you put in the will fully and completely cover what aspects you're trying to address in that will. So don't assume stuff's going to be in there, and hence oftentimes why you should be engaging knowledgeable legal counsel. You want to make sure what you want and all that you want and things that you don't want are in that will. Next thing is that the will only deals with matters upon your death. So don't expect a will to deal with matters when you're incapacitated. That is not what a will is for. That's what an enduring power of attorney or a personal directive is for. Those deal with matters when you're incapacitated or you're looking to put somebody else in charge of your estate. A will only deals with aspects once you are dead. Next, certain types of property are not necessarily included in your will for disposition. For example, property that's held in joint tenancy. So if you hold a property with somebody else in what is called joint tenancy, the surviving joint tenant automatically gets the property technically on right before your death. So you don't have the ability to sever that property or assume a part of that property and dispose of it in your will. Similarly, if a property is in a living trust, it is not subject to the will. It is controlled by the trust, which is its own legal person. Meanwhile, life insurance, where there is a designated beneficiary, the proceeds of that life insurance will not be directed by the will, it will be directed by the life insurance policy. Similar things can happen with retirement plans, designated stocks and bonds that identify beneficiaries, certain bank accounts that specify terms for payment to individuals upon death. Those things are outside the bounds of a will and will not be impacted by the will unless there is something dealing with it specifically. Another aspect you need to be careful with is certain gifting where you either invoke conditionality or there's a potential for illegality with respect to the gifting or the assignment. Because if the gifting is too complex, it requires people to do certain things, is not phrased properly, it could either be voided or it could be negated, or the person might not have to fulfill it. So in those circumstances, and if it has an illegal purpose, similarly, you should be engaging knowledgeable legal counsel to make sure that your gifting and your assignments are accurate and permissible. Finally, you want to be cautious with respect to how you deal with special needs individuals, especially special needs children. You don't necessarily want to be using the most simplistic of wills. So even though you might be able to address aspects that you're dealing with for a special needs person, you want to make sure you're doing it properly and not imposing unnecessary burdens on them, creating avoidable tax situations, or otherwise not fulfilling your actual intentions with respect to your treatment and their care under the terms of your will. So these are some of the concerns that you should have and address, and they are aspects which are not necessarily included in a will or should not be included in a will. Hopefully that has provided you with some insight as to some, but not necessarily all of those aspects. If you need to engage knowledgeable legal counsel, please feel free to contact ourselves. And we hope you have found this YouTube video informative and helpful to your putting together the appropriate will for yourself. Thank you.